Just when you think everything's black and white, maybe it is. Except I've had to be involved with the legal fraternity, with the criminal justice system. And there you discover actually that everything is not black and white. We have this thing built into our criminal justice system that means that there are discretionary powers that are used throughout and that impact the way that deviance is defined, and it also impacts the way that processes follow through in relation to criminal deviancy. So, what I want to talk to you about now is firstly, we'll start off by talking about the purpose and the process and the people involved in the criminal justice system, and then talk about the discretionary powers that exist within it. Now, firstly, the purpose of the criminal justice system. The purpose is to make sure that criminal deviancy is defined. For that, we have legislation. We have the law. We then have a process by which we mean that we have a way of dealing with criminal deviancy. So we have our judiciary. And through the exercise of the judiciary in relation to legislation, there is coercion to make sure that people adhere to social norms. So the purpose is to help people obey the law. So that's the purpose of our criminal justice system. Excuse me. Next, we have the process. We have this process that can be taken through step by step, and someone can exit from the criminal justice system at any one of these particular steps. But we have this process of a criminal or deviant act, at least, is reported. Then there is the apprehension of the person who committed that act. Then that may lead to prosecution, from there to sentencing, and from sentencing to incarceration, or at least to supervision. Now, as I said, you can exit or be exited from the criminal justice process at any one of these points along the way. Purpose: to help us to conform and to obey the law. The process goes through from observing and reporting right through to incarceration and supervision. And to do all of that, there are a lot of people. There are a lot of arms of government. There are many institutions set up to deal with that process and to deal with deviancy and to support adherence to social norms. The actors that we have, or the people involved, obviously there's the police. The police are instituted state-wise within Australia, within each state and territory, as well as we have federal police. Then there are the public prosecutors. Can't say that one quickly. Public prosecutors. That will include someone like the public prosecutors, the Attorney General. So we have people operating at this level as well. We have court officials, magistrates and judges, solicitors and barristers, and all the people involved in those sorts of court processes as well. And then we have members of the public. Now, members of the public will serve in different capacities. They may be witnesses to the act that is under scrutiny. They might be called in as expert witnesses who can give detailed explanations of what might have happened. And then they may also be brought in as jurors. So the public is also very much involved as actors within the criminal justice system. We have the correctional services personnel, prison guards and the like. And then there are special agents like the tax office or the independent commission, ICAC, the Independent Commission Against Crime. So we also have these special bodies that are set up as well for dealing with criminal deviancy. Alongside of all this, with all these people and all these steps, there are a lot of discretionary powers that are able to be used within these processes. Now, a discretionary power is a power that someone possesses, And they are able to choose whether they exercise that power or not. And they exercise it or refrain from exercising it based upon their assessment of the circumstances and the situation. Now, it means that there is a level of subjectivity that is brought into the different steps within our criminal justice system. But discretionary powers are something that exists at each of the levels of our criminal justice system. And when you think from a labeling perspective, it means that deviancy isn't just something that is inherent in the act, but it has to do with the audience around it and the things that are being said about the person and what it is that they are accused of doing. So I said that discretionary powers exist within all the levels. So as far as legislative discretionary power goes, so that's the power that the government has to say what is legal and what is illegal. So they have the power to define what criminal deviancy would look like. They can create new laws. They can repeal old laws. They can decriminalize certain activities. They can change the way that punishments are scaled. So they can say this must be mandatory punishment or not. They can also pass laws about the types of punishments and the severity of punishments that can be offered. And they can change the basis of the criminal accusation and of sentencing. So at a legislative level, there are discretionary powers that can be exercised that impact the way that a person may or may not be described as a deviant. We have policing, and the police have discretionary powers. It's just part of what they do. Now, they can be exercised in different ways. Part of it will be that they are able to decide, yes, do we follow through with this and actually make an arrest, or do we let it go? Discretionary powers amongst the police have the advantage of them being able to turn a blind eye if they think that this isn't something that we should follow through with, or there are certain circumstances that are mitigating here that we need to take into consideration. But it also means that they are able to use their powers and then maybe being accused of over-policing. Now, in particular, where there are marginalized or disadvantaged persons. So discretionary powers, you know what they say, always use your powers for good. They can be perceived to be a good thing that police are able to exercise, but they are also criticized at times because they use their discretionary powers inappropriately. And when that happens, one of the difficulties that we have for our criminal justice system is that the public begins to lose trust in what is happening. There are also judicial discretionary powers as well. These operate at a whole range of different levels within the judiciary. What evidence is appropriate and admissible? That is something that is at the discretion of those involved, and the judge may say, no, not admissible, don't want to hear it. There is the interpretation of the law that will come down to what the individual judge or magistrate will decide. There is bail to be decided. There is a selection of the jury. Do we want mostly men in this jury? Do we want people who are sympathetic to this issue? So a lot of discretion involved in the selection of jury, in the type of punishment and in the severity, whether there is parole to be offered or not. And judicial powers are the sorts of things that can become political hot potatoes. Things like government saying, well, we're going to make sure that these crimes are met with a mandatory sentencing. And they're the sorts of things that get taken to elections and become quite controversial within the community. When it comes to sentencing, there are many options that are available as well. These will include cautions being given, suspended sentences or good behaviour bonds. There can be a fine issued or maybe community service, probation, prison. There may be a mandatory sentencing to to some sort of rehabilitation service or perhaps to psychiatric treatment. We don't have the death penalty in Australia, but in other jurisdictions, the death penalty is obviously, it's another sentence that could be issued. So we have all these discretionary powers at all these different levels of our criminal justice system. They can be used for good, or they may be things that the public cries out and said, no, this isn't being done the right way. So there are criticisms too of the discretionary powers. One of the main criticisms is that there can be great inconsistencies between comparable cases. It may be that in one court, the same sort of case is deemed to have received a lenient sentence, whereas in another court, it will be a harsh sentence. So that's one of the major criticisms. The other one is concern for the disadvantaged and marginalized. These are the people who can be over-policed. They don't have sufficient resources, financial or cultural, accessing lawyers, understanding what the court system is, what their rights are. This is where they are disadvantaged. And we can think of marginalized groups, Indigenous peoples, migrants, youth. So that is one of the other criticisms, that the discretionary powers may work against peoples within these groups as well. So, as I said, not everything is black and white, although clearly some things are. I encourage you to go and look at the lecture notes that you will find in Blackboard. There are also some other some links for you to click on and look at some other materials and some other clips there that will help tease out some of these ideas a little bit further. Wish you well as you study the criminal justice system. Bye.